and thanks again for being so punctual. I should have announced before, but if anyone hasn't found them, the facilities just straight out the door and slightly to the left. So between now and lunch we're going to have two sessions. We'll take a bit of a stretch in between sessions. This next session is on sentencing and restorative justice. We'll have the same format, a keynote presentation, and then some brief observations by panel members, and then participation of the full audience. This time, during the participation by the full audience, we'll show the slide presentation that's been produced by the Australian Catholic Social Justice Council on their statement, Building Bridges, Not Walls, Prisons and the Justice System. So it'll be there just as a backdrop for you, and if it doesn't prove too distracting but helpful, we can run it again this afternoon. Well, it's now my pleasure to introduce Greg James, QC, from Sydney. I think I first met Greg at a law conference in Bali many years ago, where we had many fine bintangs and much reflection on the state of criminal law jurisprudence in Australia. At that stage, Greg was a leading criminal silk at the Sydney Bar with an encyclopedic knowledge of High Court jurisprudence and very acute personal insights into the peculiarities of individual High Court judges. It was highly amusing to me because my father happened to be one of them, and so I was able to studiously listen to him without, of course, offering him any corrections of any sort. And Greg, since then, has served on the Supreme Court of New South Wales, and he has also been very involved in his new role as President of the New South Wales Mental Health Review Tribunal. With his strong academic interests, he's also adjunct professor at the School of Law, Southern Cross University, and visiting professor and chair of the Curriculum Committee at the Law School of the University of Western Sydney. Greg's passionate commitment to social justice is legendary in Sydney, and I'm sure it will soon become well known here in Melbourne. He's one of the New South Wales Law Reform Commissioners engaged in various inquiries, including an inquiry into the law and procedure concerning the treatment in the criminal courts of those with cognitive deficits or mental disorders, and on the principles affecting the sentencing of such people. So, to open up the topic, sentencing and restorative justice, I introduce the Honourable Greg James, QC.
Once again, Frank has been very kind to me, as he was in Bali on that occasion. My life in the law has come, in a sense, full circle, because I can remember starting as a very young clerk in the Supreme Court, working in a remarkably named body called the Lunacy Office. There I worked with an interesting gentleman I never actually spoke to, because he didn't seem to speak to anybody, who rejoiced in the title of the Master in Lunacy. His function was to view the accounts produced by the committees that handled the affairs of the lunatics to ensure that each item was properly receipted and accounted for. That was the form of care given by the legal system to persons suffering from mental illness in those days. When I retired from the Supreme Court, I was involved firstly in a Royal Commission in South Australia into criminal processes, and then was asked to look at the forensic mental care system in New South Wales and to produce reforms after a review of that system that were intended to be able to be implemented immediately. Those reforms have come into place, and Tony Vincent will be pleased to know that after the many, many years since he was Commissioner of Corrective Services, or whatever the title was of the job then, those persons who were then detained in jail as having been found mentally ill or unfit for trial, sometimes for the rest of their lives, until the Governor's pleasure was known, may now be released by the Mental Health Review Tribunal. When I say those persons, I actually mean the same people, because some of them had been detained that long. The present system detains people a very lengthy period of time, whether they're intellectually disabled, suffering from some cognitive deficit or other, or mentally ill. But nothing like used to exist under the former system. So in one sense, we've had a useful reform. Moving to the more general topic of a humane justice system, such people don't figure in the sentencing regime conducted in ordinary cases by the courts. Over my life in the law, that regime has changed considerably. When I first went to the bar in 1972, I can still remember one of our district court judges sentencing a man to spend what to me seemed an incredibly long time, 5 years, in jail. That judge did so making the following remarks on sentence. Stand up, blogs. There's far too much of this sort of thing going on. An example has to be made, and I'm making it, starting with you. You're sentenced to 5 years imprisonment with a 3 years non-parole. Take him down. That was the whole of the remarks on sentence. Interestingly, His Honour repeated those remarks with different sentencing consequences about 3 or 4 times that day. Now, however, the sentencing system has changed. Those of you who wish to look at what the High Court has contributed to sentencing in recent times can look at the decision in the Queen and Wong, where the High Court held that guideline judgments from a Court of Criminal Appeal were inconsistent in Commonwealth cases with the manifold specified factors the Commonwealth sentencing legislation required judges to take into account and to balance. And helpfully, the High Court has held in another case that the intuitive synthesis approach in Victoria, where the judge intuitively will synthesise a proper balance from all these manifold factors the judge has to take into account, can exist together with a legislative approach that requires judges specifically to mention, lest somebody think they've left them out, every one of the one after another, sometimes up to 20 or 30 factors the legislature thinks should be referred to. These are factors of greater or lesser common sense importance, to the point where on Friday in New South Wales it was announced that a new aggravating factor would be added to the long list already in our legislation: having a child in your car when you commit a driving offence. We're now getting to a great deal of detail, to the point where it's obvious the legislature's lost faith in the judges properly sentencing and what they properly take into account, and the community has lost faith in sentencing serving its object. What is its object? Is it to get rid of crime, or is that an impossible utopian dream? Is it to quarantine people away from the community so, as Tony Vincent pointed out, we can all feel just a little bit better in our hearts because we haven't done it? Is it really to operate on the basis that it deters the whole of the community from doing such things? Or does it merely enable us to have a system that we've put up with for a long time because we can't think of anything much better? Over the past 2 to 3 decades, attempts to think of systems that are hopefully much better have occurred. The literature is full of references to mental health courts, drug courts, problem-solving courts of one kind or another, to the point where very recently, under the auspices of the Australian Institute of Judicial Administration and the Legal Services Board of Victoria, there's been prepared by Michael King, the senior lecturer at Monash University, formerly Perth Drug Court Magistrate, an entire bench book on problem-solving courts, solution-based judging, and the application of therapeutic jurisprudence to the sentencing regime. That's only one example of how the courts have now become deeply involved with attempts to change the system. Most states and territories have sentencing councils which are coming out with proposals for changes in the way in which we embark on sentencing. My own Law Reform Commission has followed in the footsteps of the Australian Law Reform Commission, which published the Same Crime, Same Time Commonwealth Review of Sentencing Law and Principles. Increasingly, the formal structures of sentencing and the formal processes of courts are giving way to restorative justice being implemented with particular communities. But we still have, particularly for major crime, a perception that our justice system should enforce retribution, shaming, punishment, values that do not seem to have produced much by way of assistance to trying to prevent a repetition of the very same conduct that have brought the person before the court system in the first place. Does restorative justice, in one form or another, circle sentencing, Koori courts, forum sentencing, all the manifold variety of alternative sentencing processes that try to reintegrate the person seen as the offender with their community, to restore the community's values and to bring into the process the victims so that their grief or damage is mitigated, does this produce any great change? Much is hoped of restorative justice, but the statistics so far have not shown that it is a success. Part of that, in my view, is due to the fact that often the nature of what is being sought is confused. If you're dealing with a community that is prepared to accept the offender back into the community, or can be prepared by a consultative process, then such systems will work. If you're not, or if they're not able to accept the victim and the offender as restoring the community's values through such a process immediately, you have to take some other steps. One way you can do it is through a system that has impressed me greatly, which is the Victorian Assessment and Referral Court list, which I have seen in operation down here, and which has worked very well for up to 12 months of what amount to court-monitored supervision and treatment prior to a plea being sought, and with the ability for there to be referrals. The problem with restorative justice, to a very great extent, turns on a failure to recognise that some people are not amenable to restorative justice techniques for them to be treated humanely and to achieve the result that we hope to achieve from sentencing. All too often, those persons are mentally ill or intellectually disabled or cognitively impaired, suffer from drug and alcohol addictions, and are unable to engage the services that they need and the community needs them to have in order to achieve some degree of rapprochement with their community. They don't have the skills to do the engagement, and each one of the agencies that might otherwise assist them has a problem because they have conditions for which that agency is not responsible. Sometimes it's referred to as living in silos. The difficulty is there's no such thing as a pure person in this regard. Almost all of the people with whom I have to deal in the tribunal in our involuntary forensic mental care jurisdiction are intellectually disabled or mentally ill or both, and have drug and alcohol problems and are violent because there is often no other way in which they can express their needs, and are honest according to the dictates of their own subculture, but not honest according to the standards imposed by the New South Wales Crimes Act. And not surprisingly, because it's the only way they can stay integrated with their culture. Now, forum sentencing, restorative justice within such a culture will not work. It won't serve the objects that it's intended to serve. unless we produce a different way to have restorative justice work, capable of engaging the services of the various agencies and making them cooperate. So much of what I've done with the Mental Health Review Tribunal has not only involved sitting and hearing individual cases, but trying to force, coerce, tempt, manipulate agencies to cooperate in the care of individual patients. New South Wales has a parole system, but the intellectually disabled and the mentally ill are persons who are unlikely to adapt to living in the ordinary environment, so they're unlikely to get parole. On the other hand, they could get parole if they could get the community mental health facilities able to accept them and assist them in the community. But they won't do that because the persons concerned have been refused parole as unable to adapt. So we spend a great deal of our time trying to integrate those two services so that the mentally ill can leave, if necessary on a community treatment order, having health services and parole services in the community, so the intellectually disabled can leave, having the support and assistance of the Department of Ageing, Home Care and Home and Disabled Care Services. To try to integrate all of these is the biggest hurdle we have to face. Tony Vincent referred to it earlier when he pointed out that you need to have a neighbourhood social climate of acceptance. You have to have a community with the appropriate characteristics to which persons can go. You need to have an agency that is able to service restorative justice tribunals to enable them to engage the services the community needs to repair the damage occasioned by the crimes, the offender needs to repair the damage occasioned by the crimes to reintegrate into the community, and the victims need to restore their trust in the system, to restore their place in the community, and to ensure that that community is supported. It's not just enough to say that kids commit crimes when they come from poverty, when they come from restricted environments. Having got the problem, you need to be able to engage the services to help with them. Our panel, I understand, will be telling us how systems of restorative justice operate in different contexts. I wish them very much the best. I hope that they're able to do what we have so far in New South Wales not been able to do, and that is to engage the services of a lot of other people to help them. Thank you.
Thank you, Greg, for doing what you do best, namely throwing down the gauntlet. So now we have a very fine expert panel to assist us in that task, and we invite them to be brief so that there'll be maximum time for discussion. And so I'd ask them to introduce themselves very briefly, to give something of their background as they speak to the topic and to the challenge which Greg has put before them. Wayne.
Hello. A little bit like Frank Vincent, I prepared a paper that I'm not going to actually talk terribly much to, but I will provide it because I've been interested in the discussion which occurred last night and again today. I will say, however, that this is the 20th anniversary of the Royal Commission of Aboriginal Deaths in Custody. I will say, however, that we haven't seen the changes in the public policy arena that we thought we might, because almost without exception, every jurisdiction has either not fulfilled the recommendations of Ricky Dick or at least only made partial attempt to do so. We would contend that if all those recommendations were fully implemented, that we would see a substantial difference. And why do I say that? If we have a look at those recommendations, we go to the very essence of some of the presentations that we've heard and discussions over the last couple of days. And that is what I would call front-end investment. Investment in those programs and initiatives that will make a difference to people's lives with regard to education and training, social, health, mental health and wellbeing programs to try to drive longitudinal change. We want to talk about sentencing and therapeutic jurisprudence. Absolutely. But we also heard from our previous speakers about how that's not being adequately introduced and supported through our prison systems. We are not looking at things like transgenerational trauma and what impacts, and I had some discussions with some people over morning tea. We heard about the child protection system, and by no means am I endorsing mistreatment of children. Absolutely not. It's appalling. But we ain't going to change it if we simply have an attitude that we will lock up and throw away the key of the alleged perpetrators. Because you have to do something to break the cycle. So you must have some form of restorative approach or therapeutic approach, because those people generally, and the research supports it. We want to talk about evidence-based public policy and evidence-based approaches. Then look at the evidence, people. Most of these people have been victims themselves. Have a look at the evidence about sentencing people to prisons. The evidence tells us that the vast majority of people who come out do not reintegrate into society, but they do become repeat offenders. One, because we've got a societal psychosis that we don't want to accept them back into the community and provide them with the necessary supports, whoever they are. There's part of the problem. We have a societal psychosis that says, on one hand, we want to be tough on crime, and then we heard the sorts of discussions we heard last night about when we actually run some research projects and initiatives and give people all the facts of the case without the actual sentencing option. But it's buried within 3 or 4 sentencing options, and we give that to a group of people and say, have a look at this and then study all the factors. Those people who participated in those programs generally came out with a lesser sentence than that which was actually implemented by the courts. I do not buy that the race to the bottom, or in fact, we're at the bottom and trying to see how much lower we can get with regards to our public policies and legislation. And one of the issues that I want to touch on, because I can keep going, the minimum mandatory sentencing, which has been raised, the impacts that is going to have if it gets up is enormous, and I'm not too sure whether the people responsible for the legislation or the public policy have thought this through. Because why on earth would any young person or any adult plead guilty when they know they're going to get a minimum of 2 years or 4 years in the Victorian jurisdiction? You know what? If I was in that situation, I'm pleading not guilty and I'm going to test in the court of law. Our courts are going to be clogged, our support services, our legal services are going to be clogged, and more importantly, the victims are going to be put under more stress, because guess what? As we're pleading not guilty, they're going to have to come into court and be cross-examined. It is a nightmare waiting to happen. We also heard about mental illness and cognitive impairment, and acquired brain injury through significant substance abuse. They're all issues in our prison system now. They're under-resourced, and they're not being treated appropriately once inside, but even prior to coming inside. We are not investing in the front end, so these people don't end up in the system in the first instance. And then we certainly don't look after them when they're in. We know people go in, and people take a deep breath, because on one hand we ignore the justice or the prison system and about the mental harm we're doing people and locking them up in these facilities, because they've got to be punished. They're evil people. But on the other hand, we're sympathetic to all these immigrants coming in and being locked up, and what terrible conditions they're being put under, and the mental health strain that they're being put under. And we scream from high hell, and we should, about the treatment of those people, adults and young people. But we forget about the very same and even harsher conditions that we are placing prisoners in. Thank you.
Thank you. Thank you, Wayne. Just before Michael speaks, I might just start with a little anecdote that over morning tea, one of the Jesuit social services staff came to me and said, Michael Burke is insistent that he be introduced as a judge. And I thought, oh, that's a bit strange. And then Michael introduced himself to me to point out that we'd given him a name tag describing him as Justice Michael Burke, and that's how it appears on the program. So to lawyers, it might seem that he's expressing some ambition for higher office. But
it's just that I thought Frank might still be here.
But for the community at large, it is a matter of supreme indifference. So, so it's with great pleasure and with the resolution of all misunderstandings that I introduce Judge Michael Burke.
Thank you for doing that, Frank. I was a barrister mainly in crime for 23 years. I've been a judge for the county court for 9 years, and that means that I have been the subject of trenchant criticism, both emanating from the Court of Appeal and from Neil Mitchell. And I do want to just briefly say that I agree with what Greg James has said about the recent evolution of our system. I remember appearing in front of these crusty old bastards who called themselves county court judges and reflecting on the impossibility of getting their sentences turned over. From where I sit now, it seems almost an inevitability. But the length of reasons that I sometimes come to read in my other role at the Youth Parole Board get to as high as 30, 40 and 50 pages. It's the more remarkable when you reflect that I should imagine it would take 1 to 2 hours to deliver those reasons. I think one day some poor fellow, recognising that he's going to jail, will simply say, look, I don't want to hear any more. I want to go downstairs and start serving it. Tell me later what I'm going to get. I've sat for 6 years on the Youth Parole Board, and I wanted to say something about the population of people that come before us. And many of you would know as much or more than me about that, I recognise, but some may not. We get people from the sharp end, at the sharp end. Much has been tried, and it, in the present sense, has failed. We deal with about 300 to 350 young people, and about half would be on parole, and about half would be at Melbourne Youth Justice Centre in Malmesbury. So there it is. The makeup of the population is important. Just in last year's report, I give you these figures. 35% previous child protection involvement, 16 present or current child protection order, 34% mental health issues, 27% presented with issues concerning their intellectual functioning, 14% were registered with intellectual disability, and it's my view, and others on the board share it, that there are a significant number of others who would qualify. 12% were parents. It's not a part of what I'm reading from the last year's report, but the percentage of Aboriginal young people within our population runs somewhere between 12 and 15% at any given time. The percentage within that population of young people suffering intellectual disability has been as high as 25%. The other thing I wanted to say was this, that because I'd acted in criminal law for many years, I flattered myself by thinking that I had a good handle on how those who travel badly in our society travel. I was really struck by the level and nature of trauma that young people that come before the Youth Parole Board suffer. Physical abuse, sexual abuse, and abandonment. And in many ways, that has come across to me as one of the very major problems. Many of you would be aware of the circumstance I'm talking about, but I remember one case at an extreme end of it. There was a young person who, in fact, was chained to a dog kennel as a very young child and made to eat dog food. I mean, you think you'd only read that in Dickens novels, but it happens just on abandonment. I remember a young fella, he wasn't the subject of physical abuse, but he'd linked up, at about 12, he'd linked up with his father, who'd been missing for many years, and went to visit him in Queensland, and it was decided that the father would come down and get him and he could live with him and his new family. Well, he came down to Melbourne, got on the grog with his mates, and no doubt assisted by their expert analysis of the situation, simply went back home without seeing him at all. So they're just examples. Greg, I don't have any answers, but I think it's important that we as a community recognise the reality of what we're dealing with and in some way convey that to people who do not seem to be fully enough aware of it. But I think there are two things that I can point to that are good about the youth parole system that may be under threat and should be protected. One is the dual track system. We are unusual, as I understand it, in this country in that the youth justice system or the youth parole system deals not only with those sentenced by the Children's Court, running from ages, say, 14 to 18, but also an older group running from 18 to 20. You're only disqualified from getting a youth justice centre detention if you've turned 21 at time of sentence. It was our impression that the older young people, to use the term, did significantly better than the younger people, and so we just had we just got a few statistics together in the last couple of years, and in fact, just measuring it, success on parole, I recognise this is crude, by cancellation or not, they do 50% better than the young people. Now, there are all sorts of explanations for that, but it seems to me one may well be this, taking up something that Greg said, is that badly damaged young people can be assisted if they're taught as they grow towards maturity to take advantage of the people and the systems that are made available to them, and our community needs to keep faith with that. And if it is thought by anyone within our community that the dual track system and the availability of the youth parole system for those 18 to 20 is not justifiable, or justifiable, in my view, they are markedly and dangerously wrong. The other thing I wanted to say about our system, which I think is a good aspect to it and needs to be protected, it's this. It is small. They are a small number of people, comparatively, that we need to supervise and assist, but also it is a small structure. I think about 8 people in total sit variously on the Youth Parole Board. We know we all 8 or most of them probably sit at every meeting. The combination of that and the small population means this, that what is acquired over time is quite a direct personal knowledge of the young people who come before us. Admittedly, some of us do help in terms of that relationship by returning time and time again, but it exists in any event. Now, the advantage of that, in my view, would be undermined by introducing systems whereby more young people are sentenced to youth justice detention. And it thereby, or for other reasons, the youth parole system becomes a larger structural system, even if it is said to be supported by mechanisms, that is, more people sitting, greater administration and the like. I think if that happened, a great advantage in our system would be lost. That close and direct knowledge across a small range of people who know each other well. I think that's a great assistance to dealing with the problems that these young people have, and the problems they, of course, admittedly create for our community. Thank you.
Thanks, Michael. Could I now introduce Andrew Waters and just invite our remaining three panellists to be as brief as possible.
Thanks very much. Can I start by saying I feel eminently unqualified to be up here at all, having had a mere... yeah, that's right, I'll give you some more. Having had a mere 15 years experience in the criminal justice system, and probably most of you have had more than that. But I've been really benefited by being here at the conference last night and here again today. It seems to me ultimately all of us would agree that there's no easy answers to the problems we're confronting, but that probably if we wanted to really do something about it, we would have to address fundamentally the disadvantage and inequality in our community, and that's really hard. We're here, and I was invited to talk about sentencing and restorative justice, and my experience of the restorative justice process that's operating in the Children's Court in Victoria through group conferencing, and I'll do that briefly. I recognise that any sentencing option, as we've been discussing here, probably is going to have a limited impact on the rate of crime in the community, but nevertheless, here it is. I first became involved with the group conferencing process when I was in university days, and I was introduced to a Catholic country copper called Terry O'Connell, who's in Wagga, and decided that he'd had enough of just charging kids and processing them and sending them to court, so he wanted to try and do something different. So he started convening these conferences, and he travelled to New Zealand and saw what they were doing there, and he got some other people involved. But ultimately, he as a copper sat down with a group of people, the offender and his family or support people, the victim of the offence and their support people, and he had a chat, and they talked about what had happened, why it had happened, what they could do to maybe repair some of the damage that had been done, and what they could do to try and help this young person stop getting into trouble again. And off he went on this program. It operated for quite a number of years, and I went up and stayed with him and saw how the process worked. More recently, I've had the good fortune to be involved with the group conferencing program that's run by the Jesuits as part of now a legislated program, which replicates that type of process. And again, it's a conference process where rather than just sentencing a child in a sterile courtroom, you send them off to this group conferencing process where they sit down, ideally with the victim of the offence, not always, but with their support people, with the police officer, the informant, with their lawyer, that's me, and other people who are involved in the offence. And again, they just talk about what happened. Why did it happen? How can we repair the harm that's been done? And what can be done to help this young person stop from getting in trouble again? And look, it may be only a small aspect of all this, but it's one way that we as a community can get involved in the sentencing process. And I'm all for trying to encourage more creative and alternative sentencing processes rather than just, as I say, being sentenced in a sterile courtroom, which sometimes I think can have a very limited impact on a kid. I think the victim having the opportunity to see the person that they've offended against can have an impact on them, a greater impact sometimes than just being sentenced in a courtroom. And I think it can be a great process, as I said, from the community and from the victims. What I've seen from the conferences that I've been at is almost invariably at the end of the conference, no matter how angry and upset and wanting to vent the victim has come to the conference, at the end of it, as I say, almost invariably they're saying to the young person, we don't want to punish you, we just want to see you get on the right track and not do this anymore. And that ties in with a lot of the other comments that have been heard from others about when people are fully informed about the facts, when they see the person, when they understand where they've come from, they don't have a lock them up and throw away the key attitude. They tend to want to be like us and actually try and help them.
Thanks, Andrew. Kerry Walker.
Thanks, Frank. At the Neighbourhood Justice Centre, it is a centre that has a court in it, and that is spectacularly different in itself, in that the court is not the centre of what we do, the community is. My belief is that courts are their own worst enemy, that a modern functioning court has to play an active role in its community, that the nub of restorative justice is about the breaking down of anonymity. It is allowing that person to actually be in a relationship. And as many of you would know, that prior to the sit down with the victim, that the work that is done with the young person is in fact drawing that young person into a range of very viable supports and helping them reflect about who they are, and in fact helping them restore themselves to themselves. You know, this notion that offenders are all, like we see on television, as we know, many offenders, as has been said by other panellists, have come from hard times themselves and have been greatly victimised. So to restore themselves to themselves is the first key of restorative justice. The other thing I would say is that courts need to be regendered. They are male in their thinking, they are male in the way in which they deal with justice, and they are extremely rude places. You know, defendants sit behind their lawyers, they are rarely even mentioned as being in the court, they are rarely spoken to, they are rarely asked to tell some part of their own story, and they are rarely asked if they in fact understand what has happened to them. To say that this is a good way for us to model how we want the ultimate judging in our society to be, I think, is of a very poor standard, and courts really need to look at it. Courts, again, I think are their own worst enemy, in that often it is the judiciary who are the hardest to push on reform and act, I think, in ways that do not think laterally about how to engage community. So, for instance, rather than go back to building a whole lot of courts back in communities, you could simply zone courts internally, which has happened in Philadelphia with some great success. And so that you could have Mick Burke deal with this number of suburbs, so that his contextual understanding of sentencing would be greatly enhanced, because he would understand where people come from. It would give people who come before the court a certainty about who will be sentencing them. It will give them a certainty about who they come back to be accountable in that court. It gives services a chance at building a relationship with courts. Courts are very difficult places to build relationships with, and I hear a lot about services not doing this and services not doing that. But to call a mental health list an assessment and referral list, I think is just endemic and symbolic of what the problem is. We don't even call it what it is. So as a service out there, how would you know that the assessment and referral list is actually a mental health list? The other thing I would say is that the therapeutic jurisprudence, really what that demands of courts is to look outside the four walls of the courtroom, to be engaged in what happens to the offender before the court, outside the courtroom, beyond the courtroom, in their ordinary lives and in their sustainable lives outside the courtroom and in a non-offending lifestyle. So there are particular challenges which I don't think are beyond the courts. They take will, they take courage, and they take a bit of wackiness to do, but it is time. I think that the Neighbourhood Justice Centre has shown that it can be done without turning the courts or the law on their heads, that it can be done in a way that does engage people in the community, break down anonymity, and really gives community an opportunity to take those who have offended against it, to take them back and to look after them and to hold them in relationship.
Thanks, Kerry. And now Daniel Briggs, who's travelled from the northwest of the country to be with us here in the southeast corner.
Thank you. Could I begin by acknowledging the traditional owners, the Wurundjeri people? I think I had a few things I wanted to discuss or talk about, but I guess from hearing presenters on this panel and the panel before us, I think a couple of things come to mind, and I think that are most important. That is community involvement and inclusion, and how you treat people. So I'll just touch briefly on that and a bit about my experience in that. I'm currently working in the East Kimberley in Kununurra. I'm doing some civil law with the Kimberley Community Legal Service. Before that, I was with the Aboriginal Legal Service of Western Australia as an articled clerk and then as a solicitor. Before that, I was in Victoria. I worked for the Department of Justice in the Koori Court. So I was the first Koori Court officer when the first Koori Court started in 2002 in Shepparton. I worked there with Kate Audie, who you heard from this morning. She was the inaugural magistrate there in the Koori Court. Koori Court, as I guess those who have been involved in it have heard this so many times, but it changes lives. And I think that it's an important model that the rest of Australia can take note from. There are other alternative sentencing courts around Australia. I think that probably the Koori Court is probably one of the most thought out models in terms of how it incorporates or includes the community. We always acknowledged that it was never going to be a success because of any one person in the Koori Court. It was always going to be because of the team that worked in the Koori Court and of course the community that supported it. I think supporting the Koori Court and including community doesn't necessarily relate to the forums that we used to hold, where we used to provide awareness to the community about the Koori Court. With these kinds of alternative sentencing models comes a lot of fear and a lot of negative views about how justice is or isn't dispensed. By holding community forums, we allayed a lot of those fears and I think changed the views that majority of the community had when there were negative views about it. In regards to the defendants or those that appear in the Koori Court, and of course those that aren't necessarily defendants but in some way have some involvement in that process, I think it's a life-changing experience for all. Probably, I shouldn't say never before, but not too often would defendants be involved in the court system in a way that they have an opportunity to be involved when they front the Koori Court or when they elect to go there to be sentenced. I think, again, as it's been said many times before, not only are defendants appearing before a white magistrate who's sitting in the court telling them something that they've probably heard time and time again, they're sitting before very senior people in their community, and that has quite a positive impact also. In my experience in Western Australia, coming from a model or being involved in a model such as the Koori Court here in Victoria and then going to Western Australia, it was actually quite confronting. The justice system there, and certainly not pointing a finger at anybody, but it's almost as though you're sort of stepping back in time in how the justice system deals with defendants. It's interesting that we sit sometimes, I would go on circuit, places like Halls Creek, for instance, 360 odd k's south of Kununurra, and you'd have to get through a list of 120 or so people in a day, and it just doesn't, the system just doesn't afford you the time to deal with people in a way that you'd like to be able to deal with people. you're never compromised as a lawyer, but you're certainly put in a position where those shortcuts are often thought about as a way of getting through today. And of course, you don't take the shortcuts. Of course, my better judgment has always guided me well. But to be involved in a justice system or be a part of a justice system where you feel as though it's not serving the community in the way that it could is disappointing. Again, I don't think it's the blame of anyone in particular. I think it's just probably traditionally and I guess historically the way the court systems are. But again, coming back to the Koori Court model, it's a model that many other states and territories have all, I guess, looked at and wanted to adapt their justice system or somehow incorporate Koori Court model or aspects of it in their justice system. But interestingly enough, they seem to shy away from it when it comes down to the dollars. One thing I can say about the government at the time that supported the Koori Court was that they did put their money where their mouth was, and they fully supported that model, just as they've done with, or they did with many other Koori initiatives in this state. Other states, when we, I guess in the early days of the Koori Court, in the first 2 years when I was involved in it, took a lot of interest in the Koori Court. They wanted to know what it was about the Koori Court that was successful. It's those things I've spoken about being inclusive of all in the community. But as soon as you come to talk about the dollars, they seem to shy away and make excuses, and they say it's all too hard, and they say, well, you know, if it costs $1 million, we can put 500 grand up maybe. And I think that when you fund it half-heartedly, or you fund models like that half-heartedly, you get half-assed results, I guess, and it ends up being a waste of time. And it's not always the government that cops the flak. Government cops the flak at times, but it's also the Koori community that ultimately cops it, because it's people like myself and other Indigenous people that have to answer the questions to the community when people say it's just a waste of time, why do we have 2 sentencing models and we shouldn't have used taxpayers' money for that. So credit to that government for supporting it and I guess making it the model that it is, and of course changing the lives that it has changed. Kate Audie said earlier about, or mentioned one matter that appeared before her that I was involved with also, where a young lad had come in, and this again comes back to the inclusion part. And I remember this lad, although unique in many ways, his case is very familiar to many others, and that is that he said that he finally felt as though he'd been heard. I've sat in Koori Court on many occasions in the past where I've seen grown men cry, and they say that that was the first time that they've ever been heard. Thanks.
Thanks, Daniel. So now over to you. Once again, if you could please identify yourselves briefly and wait until the microphone gets to you.
Steve Mile, Magistrate. Just taking up the point, I think, of Andrew, the group conferencing in Victoria has been enshrined in the Children, Youth and Families Act now for some time. Anecdotal experience from many magistrates in that jurisdiction is that it's a sentencing option that provides a greater degree of confidence in magistrates that the young person who's before the court has an appreciation of not just their own conduct, but the effect of their conduct on the victim. That disposition that's under the Act seems to me a perfect counterpoint to the increasing strident commentary from victims groups, which is part of the overall balancing act in sentencing. It's one of the competing interests that sought to be served by the sentencing process. I raise it with the panel more broadly, and I know this was raised at a number of conferences previously, in particular the 2000 Criminology Conference in Adelaide. I think Professor Eileen Baldry, I think it is, has done some work in this area about transposing the group conferencing in the children's court to the adult jurisdiction. And given that there is this clamour for retribution, this desire for punishment to be meted out to convicted accused by victims groups. There seems to me the opportunity may be for there to be consideration of group conferencing in the adult jurisdiction. Given the prevalence of offences against the person, particularly in courts of summary jurisdiction such as the Magistrates Court, which is a matter of simply bread and butter work on a daily basis, Monday to Friday, in a typical mention court, there is just a raft of offences against the person. There are many victims who don't make a victim impact statement. There are many victims who probably are unsure as to whether to make a victim impact statement or even aware of it. But to the extent that they don't, and that remains an unmet or unserviced need or interest, it seems to me that there ought to be consideration for extending group conferencing to maybe for a limited period a defined group of offences in the adult jurisdiction. It could apply also to the county court, and Mick Burke would be dealing with this, particularly where there are cases in the county court which, notwithstanding the Court of Appeal's view about particular sentencing in certain cases, where there is a non-custodial option is open, inviting the victim to be part of that process in a group conferencing process. I've simply raised it with the panel to see what views you have. It seems to me that the anecdotal success so far of the Children's Court could be extended. It may be one way in which there can be an overt, direct, presumably, and one assumes, well-funded commitment by the state through the judiciary, I guess effectively, albeit for the separation of powers, but by the judiciary, but supported by policy by the state, that victims have even have a different way in which they can participate in the sentencing process. In short, I've seen many victims who have, a number of victims at least, who have given direct feedback in the sentencing process to say the fact of their meeting the accused in a monitored, managed, considered circumstance, such as a group conference, has meant they as victims have been able to resolve all the issues that are implicitly part of being the victim of an offence. And I'll give a very short anecdote of a 60-year-old milk bar proprietor in a regional town who was assaulted by 2 or 3 young 16-year-olds, and after the assault he hadn't ventured out of his house for some time. The court took some time to get to the Children's Court of that regional town, and in the sentencing process was contacted to say there's a group conference been referred by the magistrate. He attended in the company of Police, Department of Human Services, the referral agency, and in short, the feedback was he turned up to the sentencing and said it was only having had that and met the accused, he then no longer felt unsafe and was able to go back to then go about his milk bar, go about his, in a small regional town where there was a high probability of going to be just coincidental contact with the accused. But that's just a simple example of one particular case. It seems to me illustrative of what could happen in the adult jurisdiction, particularly given there's this law and order, this mantra, this reaction, this drive against accused, and the desire for punishment.
Can I just respond very briefly to support that? Because I think there's a great fear for many people who've not experienced it in putting a victim and an offender down together in the same room. And there's a reluctance to do it. I've found it with some magistrates in offences where I've thought it would be a really great opportunity to have a group conference, and they've been reluctant to do it because of the fear of putting the victim in that circumstance, where it can actually, and in my experience has been, an incredibly empowering experience for the victim. That great fear, as you talked about, Steve, of a victim not being able to put a face on the person that's committed a crime to them. You imagine the boogeyman, some monster that's committed this offence. We're actually meeting them in, as you say, carefully managed environment. Can put a face to that, put a real story to that, put all the background history to that, and you know what's led to it. And as I said, almost invariably the victim comes out of that not just being less fearful, but in fact expressing a desire to want to help that person to put their lives back together.
At the Neighbourhood Justice Centre, we in fact piloted an adult restorative justice program that was at the suggestion of Jesuit Social Services through the Attorney General, Rob Hulls. What we found was that the 18 to 25-year-old age group was quite difficult to engage in the process. They were quite well defended emotionally. I think possibly as part of their development. It's the time when you feel fairly invincible in your life, and they weren't as happy to engage. And what we found was we needed to do have different types of configurations of meetings and almost a shuttle type of relationship that's often used in mediation. The other comment I would make is that in the adult system in New Zealand, that the majority of cases are in fact culpable driving cases, where it isn't the stereotypic offender. It's about being in the wrong place at the wrong time and something shocking, dreadful, and tragic being an outcome. And what the workers have talked about is how at the end of the conference, yes, everyone's very happy, the victim's very, very happy. However, if you follow them up 12 months later, they think they wish they had never gone through it, that positively charged encounter they now feel, and it's a bit like after a funeral, you just feel left on the shelf. And some workers have remarked that they think that that's about the unattended grief, that we in fact need supports for victims well after the encounter with the offender, no matter how positive it seems at the time.
Yeah.
Jenny McCarcos. Greg James, in your contribution, you referred to politicians tapping into community attitudes around sentencing and a loss of confidence around sentencing. I was on a parliamentary committee that did an inquiry a couple of years ago that looked at violent offending, and we particularly did some research that covered media coverage of violent offences for a 2-year period. And you may not be surprised by the findings, but we found that the media coverage in no way reflected accurately the extent of crimes occurring, violent offences occurring. There was one newspaper in particular that shall remain nameless that's in particular focused on violent offences around nightclubs for a good 18-month period, and seemed to be driving a lot of the public commentary around these issues, in particular around sentencing. So I guess really what I'm wanting to put to the panel and to all of us here today is in terms of how we look at the outcomes that might come out of this conference and the call to arms that you're going to be discussing at the conclusion of this conference, is how we can all tackle these issues around building greater confidence by the public in the role of the judiciary, developing a greater public understanding of the sentencing principles that the judiciary are required to undertake, and how we counter, I guess, the shock jocks and those in the media who wish to sensationalise criminal reporting for their own political agendas. So I'm just really wanting to focus the panel's attention perhaps on that issue. Thank you.
New South Wales has had a similar result. There is a huge upswing in vicious and violent crime in your suburb. The radio announcers, the front page of the popular newspapers in Victoria and New South Wales make that entirely clear. The Bureau of Crime Statistics makes it entirely clear that in New South Wales at least, violent crime overall is falling. That's not surprising when you think that New South Wales originally was founded in Sydney, a port city of convicts, that remained a port city in which one of our poets celebrated getting him down, kicking him and hitting him with a brick. That's one C.J. Dennis in a popular poem. We have less overall violent crime in New South Wales on a per capita basis than we used to have. That doesn't mean that we have lesser sentences. In fact, the sentences have become increasingly longer and longer and longer without any demonstrated value to the community. The judges have become increasingly disquieted about it, particularly when they're asked to take in a whole raft of considerations when passing sentence, such that each sentence is taking much longer to consider, much longer to deliver, and much, much longer to serve. It's not a popular stance to say that sentences would be as useful if they were 3 years instead of 5 years. There are people who seem to believe that the longer and harder the punishment, the better everyone else is off, until they or their loved ones get charged. But providing resources, as Professor Vincent has suggested, at the outset before people come into the system to deal with the conditions that bring them into the system, providing the resources to divert them from the system into a pathway that is likely to produce value for the community, rather than simple quarantine, which is often what happens in jail, and providing systems to take them from jail to transition into the community back again, is, both in economic terms and community terms, far more profitable. From the point of view of victims, it's far better, because that victim gets some degree of safety that the simple provision of a victim's impact statement to a court when sentencing does not give the victim.
One and then...
Is that right? Yeah. I think, Greg, you're right about... you're very likely right about our society being less violent than what it was. But speaking from the youth point of view, the crime rate hasn't gone up, but I think I heard somebody say it when I arrived earlier, and it's right. The proportion of violent crime within our youth system, or within our youth offenders, has certainly gone up, and I don't think we can step away from that. I think we have to admit it. I think the issue that you raised plays a little bit into the issue raised by Steve Mile. There is misinformation in the media, and in some ways it's because our system historically hasn't given victims a proper role and therefore a better understanding of what our processes are about, and therefore they're left with the opportunity to engage in the rhetoric. They can ring up Neil Mitchell and let fly. We need to remember what we were like. Police used to run this way only 20 years ago. No victim impact statement, but forget that. The Crown didn't even open the facts. The depositions were handed up to the judge. And I remember being about prosecuting a manslaughter plea in front of a county court judge in Horsham years ago, and that happened. And it was a light sentence, appropriately light. And then it was only then that I met the family of the dead person, who made this point to me, that their brother, their father, their husband's name wasn't even mentioned in the hour which the play ran. So we were pretty bad at it. We're a lot better at it now, but I think the better we get at it, the better the community will understand that our system's not as bad as it looks. For example, the recent Tasmanian research into what jurors thought of jury trials tells you the story, I think.
Yes.
Hi. Catherine Anderson from Youth Services and Youth Justice in the Department of Human Services. I just wanted to come back briefly, if I may, to the comments from Andrew and from the floor about Victoria's Youth Justice Group Conferencing Program, and just to build on some of the flavour of the anecdotal positive comments to highlight for people the findings of a recent evaluation of the program, an independent evaluation by KPMG last year, which found that on a number of fronts that program was delivering positive outcomes compared to a control group, if you like, of young people with similar offences who went down a different road, a different type of process. Those who participated in the group conferencing program reoffended at a lower rate than those who didn't participate in that group conference process. It was very cost effective, as you would guess, compared to community-based supervision, or obviously compared to an outcome of youth justice custodial detention. And probably most interesting, the participants across the board, both the young people and the victims who participated in that process, were highly satisfied with the outcome of that process. So on the back of that evaluation, we've put forward a proposal for increased funding for that program, and the Victorian Government has committed in its most recent budget 5.15 million over the next 4 years to significantly expand the Youth Justice Group Conferencing Program by an additional 650 group conferences over the next 4 years, and with an allocation in that budget increase for some further support to victims who participate in the process.
I should point out the next speaker is John Hassett, who was my Master at the Bar in 1978 and served for many years on the Catholic Social Justice Council and did a lot for the reform of sentencing procedures in the county court. John.
Thanks, Frank, and I'm pleased to see that you've survived your experience in my chambers many years ago. All of us here, I imagine, are one way or another concerned to see less people go to prison and to see lesser rates of imprisonment overall, by which I mean not only numbers but length of time. When we're talking to people who are not of that view, people who, because of public perceptions arising from the media, think that sentencing is too lenient, if we start off talking about the sort of things we've been talking about here today, they're likely to turn off. They're not interested. You're immediately a lefty or whatever it may be. I think it's important from that point of view in dealing with ordinary members of the public, people who are not informed, as we are, about the criminal justice system, to point out what it is we're really on about. And that, I say that in the context of two things. Firstly, the observations of Greg James about the objects of sentencing, whether punishment, warehousing,